my name is Erin Deedy. I primarily work with local governments throughout Florida, and I have a client in Louisiana working on sea level rise and climate change. So I'm going to talk a little bit about what the planning framework is for Florida local governments. I have evolved my presentations where I don't spend a lot of time with charts and graphs and science and data anymore, which is a good thing. Now I just kind of talk about planning and how this integrates with planning, and then I'll talk a little bit about the law and how that's shaping some of what we're doing. This is primarily Lower Keys, Big Pine area, US 1. This is using the climate sea level rise projections for the Southeast Regional Climate Compact at 7 inches at 2030, which is their high scenario. This is 2060 with 24 inches of sea level rise. Big Pine literally is split in half into 2 islands. And you know, this is one particular community in terms of what they're looking at, but it's indicative of some of the hard choices that local governments are having to make across South Florida and Florida in general. These are sea level rise inspectors in Monroe County when we were out looking at some of the king tide flooding in 2015 and 2016. This is my client Rhonda Hay. These are her dogs, and we kind of run around and take pictures of flooding when we have the king tides, and we've been doing that over the past week. These are all roads, and this is salt water, and it is not raining out, so we're going to be seeing more of this, and the point is that we're seeing it now. This is not something off in the distant future. So I'm going to talk today about some of the facts regarding climate change and law. I took this picture in the front of a bar in Ybor City. I thought it was really indicative of some of the quote-unquote factual conversations that I have with people about climate change. I'm going to talk about some examples of who's doing this across the state of Florida, so it's not so scary for other local governments to engage. What happens if you don't start incorporating best data into your comprehensive plans and your development decisions, and some of the kind of interesting evolving new law on the topic. So first I'm going to talk about Florida. You know, it's a great tagline to be able to say that the state of Florida is doing nothing about climate change, but it's just a false debate in my opinion. We've had a lot of law and statutory provisions that kind of eat around the edges and then look at greenhouse gas reduction strategies. We got adaptation action areas and the peril of flood legislation in 2015. That is really a driver now for local governments to integrate these concepts into their comprehensive plans. But the fact is that we actually do have the word sea level rise in our Florida statutes. And the core of this legislation that passed in 2015 is for local governments that are required to do a coastal management element of their comprehensive plan. They have to address these 6 things. And this is not self-executing. It was passed in 2015, but the next time a local government is coming in and doing kind of an ear-based review and update of their comprehensive plan, you have to bring your plan into compliance with the state of the law at the time. And that includes these new requirements for your coastal element of your comprehensive plan. And many local governments are already starting to go through that process with the Department of Economic Opportunity. And what I'm seeing is a real shift that local governments are starting to realize that their comprehensive plan is kind of where the rubber meets the road. It's your long-term growth strategy. It makes sense to put it there. It's based on data and analysis, and you would have goals, objectives, and policies supporting that in your comprehensive plan. So it has been legislatively driven, but that debate is no longer a debate, in my opinion. It's actually playing out in local government comp plans. So example planning efforts around the state of Florida, there's no one-size-fits-all. There are local governments doing what I would call duct tape adaptation, which is project-oriented kind of work to deal with sunny day flooding. And then there's long-term and regional planning. Just last week, the Tampa Bay region. I think it was 19 local governments signed off on an agreement to start regionally planning together, modeled after the Southeast Regional Climate Compact, which their big climate summit is October 24th through 26th in Miami Beach this year. So regional planning has kind of seen a resurgence in terms of science, sharing science, having joint science with sea level rise projections, and exchanging information and data. And different local governments are dealing with different issues. For instance, St. Augustine has some real unique issues, as does Key West with historic properties. There's a big conference, I don't know if Clay's still here, but Keeping History Above Water is at the first part of next year and talks a lot about historical assets and how to protect them from sea level rise. So the point is that there are a lot of local governments doing a lot of work on this throughout the state of Florida. And a sample planning strategy would be in the short term, kind of that project-oriented approach, like I was talking about the duct tape adaptation. Mid-range, you're starting to integrate this into goals, objectives, and policies in your comprehensive plan, and land development regulations in the long term, kind of the sacred cow. You're really starting to deal with how do we make different decisions in terms of land acquisition and development and where and how we should build. And what I would say probably one of the toughest decisions that we're going to have to make is what level of service can we actually provide for drainage and roads in the face of sea level rise, climate change, increased flooding from different precipitation patterns. All of these things from a policy level are longer term, but for a local government that's looking to get started, this is how I kind of categorize those different efforts. Here's one example. Monroe County has passed a resolution to change its road design criteria to account for sea level rise using a certain prediction or projection for the useful life of that road. So if the road is going to be in place in 25 years, figure out what elevation you need to be at to avoid that sea level rise at year 25, and then that would be what you would integrate into your elevation standards for roads. And they adopted this resolution in 2016, and they're already implementing it with each new road project that is coming in through the county. So again, design criteria and community that's 100 miles long in a series of islands, roads are going to be one of the biggest things that they're going to have to contend with. So I'm going to kind of shift over now and talk a little bit about the law and where climate change shows up. We're seeing a lot of cases with regard to typical federal regulation that we're used to seeing, the Endangered Species Act, NEPA. I'm going to talk a little bit about money damages cases, common law claims, and what I call the Protect My Future series of cases, which involve kids litigating against different levels of government to protect resources under the public trust doctrine. Columbia Law School, if you're interested in this type of litigation, tracks all of this. They also have what they call a deregulation tracker, where they are tracking all federal and state legislation that is beginning to be rolled back related to climate-related issues. So if you are interested in that, Columbia is a great place to go. And I'm going to talk a little bit about duty to maintain versus duty to upgrade infrastructure. What does a local government actually have to do, and can they essentially see exposure for not potentially planning? And we have an interesting case that I'm going to talk about, Jordan v. St. Johns County, in terms of government inaction with failing to maintain roads, and what does that mean from a takings perspective. So torts and sovereign immunity and takings are kind of where we're seeing a lot of climate change law evolve. One particular case, Hurricane Katrina, the levee breach cases, initially they were filed as an action against the Corps of Engineers for failing to maintain that levee system under a theory of tort, that it was negligent. The Corps eventually got off in that line of cases under a theory of sovereign immunity, but then the property owners whose properties were damaged refiled the litigation under a takings lawsuit. But for Corps, you not maintaining the federal levee system, my property flooded. And this was interesting because it introduced the concept of a temporary taking, like if property was only flooded for a portion of time, could that rise to the level where it required compensation? And here's a quick graphic of what that federal levy system looks like and how the storm surge just kind of came in and overwhelmed the levees around New Orleans and collapsed them. There was an award at the lower court level under this takings theory where $316,000 of judgment against the Corps for failing to maintain that system. The Department of Justice appealed, and essentially that damages judgment was overturned because that would have opened, pardon the terrible pun, the floodgates of litigation against the Corps for failing to maintain levees across the United States, which is a very hot area of litigation right now. And what the court ultimately found was that the Corps could not be held liable for not doing something. Government inaction and government agencies could not be held liable for not maintaining the levy system and thus adversely affecting people's property values. So remember that. In this federal case, government inaction, not something that you can hold in terms of a taking. St. Johns County, though, very interestingly, and an appellate decision did find that government inaction could be something that rises to the level of a take. And what that means for sea level rise is if the government doesn't maintain potentially a roadway system and it cuts off access to people's properties, and this particular very, what I would call obscure decision, inaction could rise to the level where the government has to pay out compensation. So this was an unusual case. It's the only time in Florida an appellate court has ever held that government inaction could bind takings liability, and then we have contradictory federal law. So it's kind of an open question as to whether or not local governments have to maintain roads in the face of flooding conditions. And we're a group of, myself and a group of other attorneys have been working on a law journal article to try to get to this question across 4 states. The Borough of Harvey Cedars case is an interesting one out of New Jersey, where the court came in post-Sandy, wanted to work on a dune restoration project, and property owners challenged that dune restoration project because it would have impacted their view, where a lot of takings cases kind of reside. It was even proven out that the people's property value was going to increase with the dune restoration project because it was going to be more secure during further storm events. So the question becomes, if a take occurred, what is the just compensation that you pay the people saying that my view has been impacted? So at the lower court level, $375,000 was awarded to this couple. This case went to the New Jersey Supreme Court, and what they did was they introduced this burden benefit calculation into the compensation, saying, hey, we really need to factor in that this property is going to become more valuable because of the dune restoration project, and we shouldn't just be paying out with the impact to the view. So once they did that different compensation methodology, does anybody want to guess what the people were awarded? $1. They were awarded $1. So this is the house before the dune restoration project. This is Chris Christie overseeing the work being done for the dune restoration project. And then here's the view after the dune restoration project. So clearly there was an impact to the view, but these property owners were also very clearly going to benefit from the dune restoration project. So what does that mean for sea level rise? Local governments should take this into consideration, that the property owners that say, hey, you can't do that adaptation project, it's going to impact my view. Well, here's a theory of cases that say we got to look at the benefit as a whole of what that project is actually going to provide. So nuisances, planners, when we think about nuisance, we think about junk in the front yard or vacant properties that we want cleaned up. And meanwhile in South Carolina, I guess I need to update this. It's probably a little raw in the panhandle right now to have memes like this. But in South Carolina, nuisance can mean water. And there are a lot of cases that have been involving trying to get at this issue of the fossil fuel industry and their activity in terms of contributing greenhouse greenhouse gas emissions to global warming, and is that a nuisance? For instance, Kivalina, an island off of Alaska, sued the fossil fuel industry for $400 million because they have to relocate the population on the island because of sea level rise. But for you fossil fuel industry doing your thing and emitting greenhouse gas emissions and contributing to global warming, climate change, and sea level rise, we wouldn't have to move. Now the difficulty with this is apportioning what the fossil fuels contribution is versus what we're going to do after we get out of this workshop today, which is get in our car and drive home. We're still emitting greenhouse gas emissions. So that causation linkage is very difficult. There's a new line of cases where local governments are now trying to sue the fossil fuel industry for the same type of theory, saying, but for you doing what you're doing, we wouldn't have to spend hundreds of millions of dollars on adaptation projects. This is playing out in the court system right now, so it's going to be very interesting to see where these cases go. But again, interestingly, in that new line of local government cases, the San Mateo case, local governments are using their vulnerability assessment, saying, look, we've even planned and we know how much this is going to cost, and we have to pay for it. So you need to stop doing what you're doing and, not making us have to spend all of this money. Negligence. This is an interesting case that I'm watching out of Texas. I think this stands, maybe I'm the only kind of person that geeks out on something like this, but we all have to carry flood insurance with our mortgage. Our mortgage company makes us carry it. And what happens if the homeowner calls his mortgage company and says, hey, I don't live in the special flood hazard area within the 100-year floodplain. Do I need flood insurance? And the mortgage company says, no, you don't need flood insurance. And then I get flooded in Hurricane Harvey. I didn't need flood insurance. My mortgage company told me I didn't need it. Can I sue my mortgage company? Well, Mr. Ali is an attorney, interestingly, and he is suing his mortgage company for negligently advising him that he did not need flood insurance when he was outside of the 100-year flood line. So what does that mean? Is the 500-year flood line now the line? It's very interesting because our whole mortgage industry is built on requiring flood insurance within that 100-year flood line. So I'm kind of interested to watch this case go to trial. There's been no pleading yet, so I haven't been able to read much on the legal arguments. Other evolving legal aspects, you can't really talk about sea level rise and climate change and flood risk without talking about national flood insurance. I don't have a lot of time to go into the issues, but suffice it to say through FEMA's community rating system program, that there is the availability to start improving your score within this program for planning at the 2100 condition for sea level rise. The Army Corps of Engineers is required to incorporate sea level rise projections into civil works projects. NEPA legal cases are still factoring climate change into their analysis and in many challenges that we have under NEPA. And federal investments for grants, especially disaster recovery money, despite the fact that we rolled back an executive order requiring federal buildings and federal dollars to be spent for more resilient rebuilding, the latest wave of disaster recovery money does require rebuilding to a higher standard. So yes, these are being rolled back, but we are still implementing these concepts in other ways. And I'm going to wind up with a couple of slides here on the public trust doctrine. It's a theory that's evolving whereby youth plaintiffs are suing, and the first case was a federal case against the Department of Energy, EPA, the Office of Management and Budget, basically saying, look, air, climate, atmosphere, these things are natural resources to be protected for my future, and under this public trust doctrine, the federal government needs to do something about protecting these resources, and what I'm seeking is, as a youth plaintiff, is some type of remedial plan. Here's a picture of the youth in the federal case. Levi Draheim is from Florida. He's also involved in complementary Florida litigation on this. I'll talk about that in a minute. But the federal government absolutely hates this case. They really hate it. They have went through, types of appeals that I never heard of or learned about in law school to try to get rid of this case. Interlocutory, in-camera appeals, trying to engage the U.S. Supreme Court to look at different procedural aspects. As recent as October 5th, the federal plaintiffs have filed yet another motion to stay discovery and move the trial in this case, which is scheduled in late October, October 29th, I think it is. October 29th. And the U.S. Supreme Court has already declined once to step in until this case plays out, so it'll be very interesting to see what happens with this most recent. I had to put 2 in there because we've had 2 of these extraordinary motions to dismiss the case. And I'm going to end on Reynolds v. Florida, which is a similar case with youth plaintiffs in the state of Florida. These cases are not about money damages. They're about trying to make law in terms of protecting climate, air, and natural resources in the public trust, which is a long-standing theory of federal and state law. And interestingly, this case was supposed to go to trial October 4th, and 4 days before the trial, October 5th, 4 days before the trial, the judge filed a motion to recuse himself from the case. So it will be interesting. Nobody knows what the conflict is. It'll be interesting to see what plays out with the Reynolds case. But this one, equally, the state of Florida is less than thrilled with this litigation. And here are the youth plaintiffs, and again, they're all from the state of Florida. So to end, I've written a Bar Journal article on all of this law and planning related to climate change and kind of moving from the Paris Agreement all the way down to the local government and why it matters. This is a great resource, citing numerous examples of local governments across the state. I updated that article, and it was published in July in the Environmental and Land Use Law Section Reporter. And to finalize, my presentation, we have been working in a group across 4 states, a group of attorneys, to really get at the issue of liability, infrastructure, and sea level rise, and what does it mean for local governments. And that is going to be published in Columbia Journal of Environmental Law probably in the first quarter of next year. And that's it. Thank you.